Hi, Matt Landsman here of Landsman Law. I wanted to take the time to go through the Fourth Amendment and what it means in criminal cases. And what that really is about is warrantless search and seizure. So without spending too much time introduction, let me just get right to it. Basically, the Fourth Amendment of the United States protects people from warrantless searches and seizures. So basically, a warrant is a document that the police officer or agent of the government has to go and get from a judge. It has to be supported by probable cause. And after a magistrate signs off on it, they can have like a warrant, like a special order, allowing them to arrest or search some one thing or place. And that's kind of presumed to be the proper way that something is searched or seized under the Constitution. However, over time, there have been a lot of exceptions that have been made to the warrant requirement of the Constitution. And these exceptions kind of swallow up the whole area of what is important in criminal cases in terms of search and seizure. So it's important to know the exceptions where a warrant is not required, which is going to be most of the time based on once you hear all of the different exceptions. I just want to go through each one and kind of briefly describe what they're like, what they mean in practical terms. The first exception to the warrant requirement is it's called exigent circumstances. Now, exigent circumstances is really a fancy way to say emergencies. The exigent circumstance exception to the warrant requirement, where a police officer is not going to need to get a warrant, is if there's an emergency of some kind, and that's usually involving harm, death, or destruction of evidence. And there's a whole series of cases and laws about those circumstances and the fine details. But essentially, if there's some sort of ongoing emergency, evidence is being destroyed, they can hear a toilet being flushed, somebody is screaming for help, they don't need a warrant to go in someplace or to seize something or to search something. The second exception, which is important to know about, is called the plain view exception. It's almost as basic as it sounds. If a plain view, if the police officer just obviously sees something that's illegal or evidence, they can take it. So the important thing to know about that practically is that a police officer has to be in a lawful place when he or she observes the illegal substance or evidence or contraband, etc. So if they've already done something illegal, gone into your house illegally, and then see something, you still have a remedy there. So they have to be in a lawful place before they observe the criminality. The third exception is called incident to arrest. So basically, they're arresting you, which means they have probable cause. A crime has been committed already. You're being arrested for it, and then for this kind of safety of the officer, they can search you for weapons, things like that, secure your property, and it's extended. This search, though, is extended to areas within your immediate control. So it's not just your physical body. It can be things immediately on you or right next to you, things like that. That can be search incident to arrest. It can be really nuancy, though, when it gets into a traffic stop where you're being arrested and whether or not the vehicle is, how close it is to you and what you were being arrested for can matter, but what they can go into the car or not, which is a different exception. The fourth warrant exception is called consent. It's very common, and basically the police need your consent to do a search without a warrant under certain circumstances. And now the important thing to remember about consent as a warrant exception is that it has to be voluntary. That means it's not supposed to be coerced or as a result of misleading you in some way. So if there's mistakes of fact or mistakes of law that the police officer is making that are misleading or coercing, that can be a problem and it can theoretically still be challenged. So the consent has to be knowing and voluntary. The next exception would be called the automobile exception, where the police don't need a warrant to go into your automobile generally if it's supported. If their search is supported by probable cause or, depending on the circumstances, reasonable suspicion. And that's because cases have come out basically establishing that automobiles and people who are traveling in them, they deserve a lesser expectation of privacy than the home. So as a result, the warrant isn't generally required for searching an automobile that's traveling. And lastly, it's not necessarily, it's kind of a category, and so warrant exception, but it's kind of a catch-all for things that don't necessarily fit into the other categories, and it's called special needs. It's a lot more rare, and that is they don't need a warrant for things like searches involving probationers or parolees, DUI checkpoints, school and workplace things. there's kind of like these special rules for that that have been carved out by the courts, where maybe a warrant's required, maybe it's not, but most likely not, as long as due process is complied with. And there's case law about DUI specifically about DUI checkpoints, probationers, things like that. And most people don't really run into that very often. So basically, those are all the exceptions to the warrant requirement, which, if you think about it, has covered a lot of subject matter. Almost every case is going to involve one of the things I just described, but that doesn't mean there aren't circumstances where warrants are required, and there's ways to challenge those as well. But that's basically the area of law that requires a warrant, and that what doesn't require a warrant generally. But I have not gone through the rules that apply to each one of those specific circumstances within each warrant exception. That can be for another time, another video. And so basically, if your case involves a warrantless search and seizure, there's some problem with it, and the police did not properly comply with the warrant exception. So, for example, they were wrong, and they actually did need a warrant, and they did a search or seizure anyways. Your remedy could be suppression of that illegally obtained evidence, and anything flowing from it. That's called fruit of the poisonous tree. So the first thing that's seized is illegal, and whatever that led to can also be considered an illegal seizure if you could succeed in convincing the judge that this first seizure was illegal. So that's basically a brief summary of the warrant requirements in the United States and Florida, and exceptions to the warrant requirement, which is important for knowing if you have a criminal case or anything like that. So I hope this has been helpful. Matt Landsman, for you.